Welcome back to AI Serendipity, where tradition meets innovation, and we always ask the hard questions. I am Santiago Martín Caravaca, an Italian-Spanish dual-qualified tech and IP lawyer, a technologist by curiosity, and your guide through the twists and turns of the SUNO AI case. Today, we are zooming in on one of the most important moments in any litigation, the request for relief. This is the part of the case where SUNO tells the court not just what they want, but what they believe they deserve to walk out of this legal battle victorious. It is concise, strategic, and, as we'll see, a window into their broader defense plan. Let's dive right into it. But what is a request for relief? Think of it as a legal wishlist, the closing chapter of a defendant's response to a lawsuit. It is where they formally ask the court for specific outcomes that align with their narrative and strategy. In SUNO'S case, this section is brief but loaded with meaning. Here's what they're asking for word. 1. Enter judgment in SUNO'S favor and against plaintiff. Dismiss all claims by plaintiffs with prejudice. Award SUNO its attorney's fees and costs to the extent permitted by law. Grant SUNO such other and further relief as this court deems just and proper. Now, let's break this down one by one, unpacking what they mean and why they matter. Judgment in SUNO'S favor. The first ask is the ultimate prize. Judgment in their favor. SUNO is telling the court, declare us not liable for the claims brought against us. This isn't just about walking away unscathed. A judgment in SUNO'S favor would set a precedent, sending a strong signal to the tech and entertainment industries. But why does this matter beyond this case? Because it is about more than just SUNO. It's not just a victory. They are aiming to define the rules of the game. Dismissal with prejudice, what does that mean in legal terms? Essentially, it is a permanent dismissal. A dismissal with prejudice ensures that these specific claims can't re-emerge later, whether it is through an appeal or a new lawsuit. It is the legal equivalent of closing the door, locking it, and throwing away the key. SUNO is asking the court to make the plaintiffs cover the expenses of defending this lawsuit, including their legal fees, of course. Now, under copyright law, specifically Section 505 of Title 17, the prevailing party can recover reasonable attorney's fees. But here's the thing, it is not automatic. The court considers factors like the relative strength of each party's case, whether the losing party acts in bad faith, the broader need to deter frivolous lawsuits. By making this request, SUNO isn't just defending their position, they are putting financial pressure on the plaintiffs. It is a way of saying, think carefully about whether you want to keep fighting, because losing could come with a hefty price tag. They reveal SUNO'S end game. On the surface, these 4 points are straightforward, but dig a little deeper, and you see a strategic narrative. SUNO isn't just asking to win, they are asking for finality, for financial relief, and for flexibility. It is a strategy that aligns perfectly with their broader defense, precise, calculated, and forward-thinking. And that wraps up our dive into SUNO'S request for relief. It is a compact section of the response, but one packed with significance. It shows us how SUNO plans to not only defend their position, but shape the conversation around copyright and artificial intelligence. Finally, we have the catch-all request. Grant such other and further relief as this court deems just and proper. This is a standard move, but don't overlook its significance. Litigation is unpredictable. New evidence might emerge, or the court might identify remedies never anticipated. This gives SUNO the flexibility to adapt to those uncertainties, ensuring they are not locked into a narrow set of outcomes. It is like a way to stay agile as the case evolves. If this episode left you curious or questioning, don't stop here, subscribe, and stay with us. Next time on AI Serendipity, we'll step into the opening moves of the SUNO AI lawsuit. From the plaintiff's calculated framing of willful infringement to SUNO'S bold counterplay of innovation, we'll unpack how both sides are shaping the battlefield for the soul of copyright law in the AI age. Until then, keep questioning, keep asking the hard questions, and remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.